So we will, as Dory mentioned at the end of the meeting, have the opportunity to talk about this. So some of you will know. Thank you. I apologize to my tech people, and I want to thank Rex Nolte for setting everything up. And I see there's a new person helping him whose name I don't know, but I will find out and thank him before the meeting is over. These things don't happen without the help of a lot of people, and I want to be sure to be appreciative and grateful for their efforts. People have differing levels of base knowledge, so we are starting sort of basic and more general, and we're going to go deeper as we go along into this. We also want to hear, if you are aware of it, some people have already done some research, I know, because they've written me. Others, I think, we're waiting to come and get the lay of the land here. So with that, I would like to invite Hugh Spitzer, professor at the University of Washington and historian extraordinaire, to come talk to us a little bit about Washington state history and the Constitution as related to the issues before us. And thank you for being here and for volunteering your time.
Let's make sure this is this live? Yeah, okay. I'm very pleased to be here. I think, as many of you know, I do a lot of my work on issues having to do with the state constitution and history of the Constitution and provisions in it. And actually, the relationship between the court and the bar from a constitutional standpoint is something I started writing about in the early 80s. I actually had my first law review piece on that when I was in law review. But so I just want to give a little bit of historical background about the WSBA and the historical context that it was formed in, and then put it in a state constitutional context. The first formal bar association in the United States was formed in New York City in 1870, composed of the best men. This is a reform movement with the primary goal of reforming judicial elections, nominating capable and honest judges, and extricating the judiciary from the Boss Tweed regime in New York. And these civic-minded lawyers pushed clean, nonpartisan professional government and courts. Lawyers like these were drivers in the progressive movement nationwide from the late 19th century up into the 1920s, and they promoted reforms to bolster a neutral legal system and nonpartisan professional administration of government generally. On the legal structure side, they had some mixed motives. They were, on the one hand, high-minded civic reform people, but it was combined with kind of an exclusionary attitude toward immigrant lawyers, particularly Jews and Italians who went to night law schools and or didn't go to law school and didn't have the proper qualifications, and they viewed these people as being dangerous to consumers. And there was this, I guess you'd say, we now recognize it as a somewhat dark side to what was happening. But by 1916, from 1870 to 1960, we went in the U.S. from 1 to 600 bar associations nationwide, with a fairly consistent agenda, restricting entry to the legal profession through requiring bar exams, and then later requiring formal educational requirements. And bar associations around the country worked to shut down alternative routes to legal practice. They didn't succeed in Washington with shutting down the clerking program. They did succeed in shutting down a lot of the night schools that were catering to immigrant people who wanted to be lawyers. So there's a very active progressive movement, upper middle class movement. And in 1920, moving forward a little bit, the Carnegie Foundation issued a report that recommended setting up a two-bar system in the country, kind of a lower bar of journeyman practitioners that would handle personal injury, divorce, debt collection, things like that, and then an upper bar of university-educated lawyers who did complex business transactions and practiced in the higher courts. Interestingly, bar leaders Elihu Root and Harlan Fiske Stone, who, as you know, went on to other careers, advocated for a unified mandatory bar, so everybody belongs to just one bar, but with high entry standards and a very tough disciplinary system to ensure high quality practice. And so bar associations and the ABA, which was formed by this time, coordinated in the 1920s and 30s in this nationwide movement for integrated bars, and the Washington Bar Association fit right into that. The Washington Bar Association had been founded in 1888 as a private voluntary association of lawyers, although their very first meeting was in the Supreme Court chambers in Olympia. And yesterday I went through early WSBA proceedings, but the earliest one I could find was for 1894, so it was 6 years after the founding. In 1894, there were 145 members of the WSBA from around the state, although the bulk of them were from Seattle and Tacoma. One of them, at one of the meetings that year, John McGilvra of Seattle gave a talk on the need for nonpartisan judicial elections in Washington state, which we got 15 years later. That was a big progressive kind of thing. John Arthur, the president of the WSBA that year, gave an address where he started with Cicero and Blackstone, and then he went on to talk about how lawyers were the intellectual elite of the community and had a noblesse oblige. He used the term responsibility. He says the law is particularly in our care. Anyway, it speaks for itself. So fast forward now to 1933. That's the year the legislature passed the Integrated Bar Act, or the State Bar Act. The Bar Association in 31, 32 went through a process kind of like this, thinking about what to recommend and what was the best way to organize things. And the annual meeting in Spokane in August of 1933, the minutes had somebody noting that the major task assigned to the officers of the association by last year's convention was passage of the Integrated Bar Act. And it was integrated in a number of ways. Not only would all lawyers have to belong, but admission and discipline were moved from the court, with a board of bar examiners, which was appointed by the court, was then moved over into the Bar Association, subject to the approval of the Supreme Court. The papers given at the 1932 convention had made it clear that, at least in Washington, the judicial branch was recognized as having the inherent power to control admission and discipline. And the purpose of the integrated bar was to ensure high-quality legal practice and to protect the public, with some of the same pros and cons of restrictive membership. But the Bar Act passed in 1933. The 1933 meeting, there were kudos handed out to Warren G. Magnuson in the House, who was running the bill for the bar. But when they were trying to figure out how to structure the bar in 1933, and some things never change, they were looking at three basic options. One, by legislation, with detail, which is what ultimately was passed. By legislation simply authorizing the Supreme Court to integrate the bar and do the job, or just by court rule. And the lawyers wanted the WSBA, because it had been around since 1888, to continue as some kind of a semi-freestanding entity. And so they wanted ultimately something in legislation that set them up. But Alfred Wsba, who is a leading lawyer, former law school dean, and when I was a very young lawyer in the 70s, he was still around making trouble. He argued successfully for legislative creation of the integrated bar because of Article 12, Section 1 of the Washington State Constitution, which says corporations may be formed under general laws but shall not be created by special acts. And it has a cousin in Article 2, Section 28. This is a kind of provision that started in the Jacksonian period because of the anti-corporate attitude of the Jacksonians, and they wanted to make sure that and by the time it got to Washington, the Grange was very much involved in getting Article 12 passed and putting in a bunch of anti-corporate provisions. But this key one was they didn't want the legislature handing out charters to artificial persons, to corporate entities, because there was going to be too much bribery and shenanigans. They wanted all corporations, including municipal corporations, by the way, created pursuant to general laws so that then people could create their own. Well, the problem with the bar was they didn't want to have just any group of bar associations, which some states have, like New York. They wanted to have a single integrated bar. And Wsba said correctly, if you're going to set up a one-off entity, it needs to be done as an agency of the state, even if it's semi-autonomous in some way. So that was the solution, setting up the bar as an agency of the state. Now, what is that? There's been debate about that for many years. There have been a number of cases, and I think your materials include a list of some of them. The Graham versus Wsba case in 1976 to me, is a key one, and I teach it every year, a couple of classes. And that is where the state auditor tried to audit the Wsba, and the Bar Association said, you can't audit us because we're not that kind of agency. And it goes to the Supreme Court, and the Supreme Court says, well, yes, they're an agency, this kind of, but not that kind. You have to look at the context. This was written by Justice Utter. You have to look at the context, and the context is that they're in the judiciary. And therefore, you got to keep your hands off of them. And we have a number of other cases like that, including the one having to do with unionization of the bar employees, where the court again said they're a judicial agency, and what they got to do is what we say they got to do. The Supreme Court says they have to do, never mind what the statute says. So as you look through the issues, as you're working through your issues, bear in mind that if you think it makes sense to have the bar continue in some kind of semi-autonomous freestanding entity structure, bear in mind Article 12, Section 1. A couple of other constitutional provisions to bear in mind. Article 8, Section 4, which is in the debt section, and then it has a cousin, which is Article 7, Section 6 in revenue. But it says, no monies shall ever be paid out of the treasury of this state or any of its funds or any of the funds under its management except in pursuance of an appropriation by law. Now, what this means to me is that if a piece of the management of the bar is somehow within the court administration, then, so if it were brought into the court, like into, AOC, Administrative Office of the Court or something like this, then you have to start thinking, how are you going to structure the fund system for this animal? Is it going to be in the court's biennial budget, which is largely paid from taxes, I think? But then it has to go through OFM, Office of Financial Management, has to go through the legislature. If license fees go up, maybe the legislature will cut back somewhere else. So that's one option.
So I'm sorry to interrupt. We have some people on the conference call. If you're on the line, can you please mute your phone when you're not speaking? Again, those on the conference call, please mute your line when not speaking. Thank you.
Another approach, if the Bar Association or the management of some of the functions were in the court, it could be set up legislatively so that fees went into an account that was outside the Treasury and not subject to appropriation. And we have many funds in this state, in state government, that are treated as being in the custody of the treasurer but outside the Treasury. And then somebody else gets to manage how the budgeting of that money, and is not subject to appropriation. The third approach is to continue the WSBA or some form of it or some piece of it as a state instrumentality under the control of the judiciary, but entirely outside the accounts system of the court and not in the Treasury, not in the custody of the Treasury. And that is essentially where the WSBA is today. It sets its own budget, it manages its own accounts, it expends and receives expense revenues, and has its own auditor. Now, one other thing to keep in mind, the last one, is Article 8, Section 5 and Article 8, Section 7, which is its cousin for local governments, but Article 7, Section 5 is the one that says that that the credit of the state shall not in any matter be given or loaned. So given is the key here. Loaned to or in aid of any individual, association, company, or corporation. No giveaway of public funds. No gifts of public funds. Now, mandatory license fees that lawyers pay for regulatory functions, in my view, are probably some kind of public fund. They're public funds, in my view. Not everybody agrees with me. I've argued some over the years with some WSBA lawyers. It may be the voluntary section dues may or may not be public funds for purposes of Article 8, Sections 5 and 7. I really don't know. They go into the WSBA Treasury. They run through WSBA books. So more likely than not, they ought to be treated as public funds based on some cases and AG opinions over the years about what constitutes public funds. But it's something you'll want to think about, try to reach a decision on, and anything you decide, there will be no certainty about it. It's just unclear what kinds of bar funds are public and aren't public. But the issue here, though, is that if ultimately you were to recommend that, let's say, certain functions of the bar, like regulatory functions, go somewhere, one direction, more court under the court, other functions go somewhere else. For instance, one of the things I know people have kicked around is in a nonprofit, voluntary nonprofit corporation. Then you have to figure out how are we going to get bar assets, say, to the sections in a nonprofit corporation. And I came up with a very complicated approach to doing this, treating that money as quasi-trust money, and so then saying, well, then it can be moved over. And then I was talking to Dory Nickpon the other day, and she said, yeah, but what about the standard approach? I was getting too complicated. I said, oh, yeah, that is the right approach, which is you have a contract, and this is done all the time, where it goes back to a situation in 1916 where Pierce County just handed over some money and the fairgrounds to a private nonprofit county fair association to run the county fair. And it was challenged by somebody who said the county fairground is public and you can't just give away public money to a private nonprofit corporation. That's a giveaway. Doesn't matter that it's nonprofit. Doesn't matter that it has a public purpose. No gifts of public funds except in support of the poor and infirm or to other governmental agencies and Indian tribes. So the court said, yeah, can't do that. So the quick fix was Pierce County signed a contract with the Fair Association, and the Fair Association promised to provide a county fair and to put on a county fair, and it would have so many cows and so many vegetables or whatever they promised to do. and the county paid them for that. And so I am pretty sure you'd be able to structure something where, say, if the sections promise to put on so many CLEs and at reasonable prices, over, for lawyers like their members and anybody else who wants to sign up, that these assets could be transferred. These are part of the little devils in the details that can be worked out, but I think that they can. That's all I'm going to say.
Thank you. I started 5 minutes late and you stayed today. That's fine. I really appreciate that. I will learn to push this button. Thank you, Hugh.
You bet.
I appreciate you doing it in your half-hour allotted time.